All right, it's 6:30. I think we're ready to start. Let me introduce myself. I'm Jimmy Acavone, the city attorney. This presentation, a lot of it is going to address quasi-judicial issues, and I understand that there are some board members here from boards that don't do quasi-judicial decisions, but I'll also cover public records law, sunshine law, ex parte contacts, and some other things that I think are relevant to your boards. I don't know how much any of you know about the quasi-judicial process and about the matters that I want to address. So if I'm going over stuff that you know and you think, geez, this is really simple, I know this, why is he talking about it? It's simply because I don't know your level of knowledge of these matters. The other thing is, I found it useful in the practice of law I think it's easier for me to know what to do in certain situations if I understand the concepts or the principles or the reasons or the rationale behind a particular aspect of procedures or policies. I found it very useful. So a lot of what I'm going to talk about will be sort of conceptual because it's easier to translate that into practical action. The first thing to those quasi-judicial members here is I want to emphasize the importance of the quasi-judicial process in city decision-making. The bottom line is the law requires that local governments, meaning municipalities, must make certain decisions quasi-judicial. It's the only way the law allows those decisions to be made. What this means is that the quasi-judicial decision-making is a fundamental part of the process of local government. The city of Tarpon Springs could not function without some person or some board making quasi-judicial decisions. So it's important, and I want you to understand this, is that from a city attorney's perspective, as a member of a quasi-judicial board, you perform an essential governmental function that is necessary for this city to operate, and that's very important. You're also a public officer under Florida law, so you have certain legal duties and responsibilities. So I'm going to try to explain the quasi-judicial process, what quasi-judicial decisions are, and your role as a member of the quasi-judicial board. I'm also going to discuss the sunshine law, voting conflicts, ex parte contacts, and the code of ethics applicable to public officers. So the first thing is, what is a quasi-judicial decision? Well, it is an administrative decision involving a specific case, a specific set of facts, made by applying defined criteria, previously defined criteria or standards, to the facts of that case as determined by the evidence which the board hears. There's a difference between quasi-judicial authority and legislative authority, and you need to be aware of that difference. Legislative authority is the power to make law, to make policy. The law essentially reflects policy. Quasi-judicial authority is the power to apply those laws that have been made by the legislative branch to individual cases as dictated by the law that the legislature or the Board of Commissioners has made. Again, legislatures and boards of commissioners make the law. Judges and juries and quasi-judicial boards apply the law to individual cases. One of the things you will learn here is that when you act in a quasi-judicial capacity, you're acting, it's kind of a combination of judge and fact finder. Fact finder is a legal term for whoever concludes what the facts of the case are based upon the evidence. It can be a jury or it can be a judge. Or in the case of a quasi-judicial board, it's the board itself. It determines what the facts are. The legislative power of the city rests exclusively with the Board of Commissioners. They exercise this legislative power by enacting laws in the form of ordinances. Some ordinances are drafted in such a way that how they apply to a person or an applicant or a business or whoever comes before you depends upon the circumstances of that case. A quasi-judicial board does not have the authority to enact ordinances, in other words, make policy. Rather, it is given the authority, and it's an important function, to decide how the city's ordinances apply to the applicants, the persons, the businesses, in specific cases using the criteria contained in the ordinances. So quasi-judicial boards function like judges and juries. They decide cases by applying the law to the facts of the case. And that is their function. Never forget that. That's their function in local government, to decide how ordinances created by the Board of Commissioners apply in specific cases using criteria that the Board of Commissioners has determined are relevant to that decision. Now, you may disagree as a citizen, and citizens can certainly disagree of what the criteria should be. And the remedy is to go back to the Board of Commissioners and using your right to petition and try to convince the Board of Commissioners that additional criteria should apply. In other words, change the law so that we as a quasi-judicial board can consider additional criteria. A quasi-judicial decision is a legal decision like the order of a judge or the verdict of a jury. It's legally binding on the parties unless it is reversed, modified, or successfully appealed. The only exception to the legally binding nature of a quasi-judicial decision is when the board's decision is advisory to the Board of Commissioners. Many of the quasi-judicial decisions done by the Planning and Zoning Board are advisory to the Board of Commissioners. But just because a board's decision is advisory does not mean that the board does not have to conduct a proper quasi-judicial hearing and render a legally supportable quasi-judicial decision. Even in an advisory capacity, you're performing an essential role in providing the Board of Commissioners with another look at the facts of this case and the possible conclusions that can be reached. Let me talk about the criteria to be considered. As I said, a quasi-judicial decision must be based on the criteria set forth in the applicable ordinances. Those criteria are the only ones you can legally consider in reaching your quasi-judicial decision. And there are a number of reasons for that, and they're good reasons. First, it is by definition the purpose and function of the quasi-judicial board, to apply those previously established criteria to the facts of the case as you find it. Second, if you consider criteria or factors other than those contained in the city's ordinances, you are encroaching upon the legislative power of the Board of Commissioners by substituting your judgment for the Board of Commissioners, for the legislative judgment of the Board of Commissioners regarding what criteria should be considered. Again, if you think additional criteria should be considered or that there are criteria that should not be considered, your role as a citizen is to petition your Board of Commissioners and try to have them change the law. It's not your role as a quasi-judicial board member to disregard criteria or come up with criteria that don't exist. Third, if you base your decision on criteria other than those contained in the city's ordinances, you are violating the due process rights of the parties. All persons have the constitutional right in the federal Constitution and the state Constitution to the due process of law. One of those due process rights is that judicial and quasi-judicial decisions affecting a person's life and property should be based on defined standards that apply equally to all and not on the whim or personal feeling of the decision maker. You violate this due process right if you base your decisions on criteria other than those contained in the city's ordinances. Finally, and most practically, and maybe most importantly from a city attorney standpoint, if you base your decision on criteria other than the ones set forth in the applicable ordinances, you open the decision to being challenged in court. And if there's one thing city attorneys hate, it's our cities being sued. Now, I can confidently tell you that public opinion is never, and I repeat that, never a factor that a quasi-judicial board may legitimately consider in reaching a decision. If public opinion was a factor that you can consider, the decision would not be quasi-judicial. It would be a popularity contest, a plebiscite, a referendum. That's not your role, to listen to the public. Your role is to take those criteria and apply them to the facts of the case as you find it. The odds are that at some point in time, you will make a quasi-judicial decision that is unpopular or goes against your grain. You have a duty not to be swayed by public opinion when making a quasi-judicial decision. Again, I come back to the point that your essential function in city government is to make an impartial decision based upon the criteria set forth in the ordinance and the evidence presented at the hearing. Now, a quasi-judicial decision is like a trial in the court system. The parties to the quasi-judicial hearing are the city, the applicant, or in the case of a code enforcement board, it would be the person cited. And in some cases, and in some boards, the public, or an intervener. The evidence will come from the city staff, will come from the applicant and the applicant's witnesses, and again, evidence can come from the public. You must determine how the applicable ordinances apply to the facts of the case based upon that evidence as it's presented at the hearing. It's important to remember that the only evidence that you may consider in reaching your decision is the evidence presented at the hearing. And as I'm going to explain in a moment, the reason for that, again, has to do with the fundamental principles of the due process of law. If a court finds that a decision is based on facts or evidence that was not presented at the hearing, the decision will be reversed. Let me talk about judicial review of a quasi-judicial decision. And I don't know that I addressed this in my handout. A legislative decision does not really have to be based upon evidence. And the legal standard to be applied to a legislative decision, should we pass an ordinance making a violation of park more than an hour or more than 2 hours. The standard that has applied through the centuries has been, is that reasonably debatable? And if the court determines that it's reasonably debatable, then the court's not going to interfere with the decision. And a quasi-judicial decision is a much tougher standard, or a higher standard. First of all quasi-judicial decisions may be appealed to circuit court. In such an appeal, the court is going to review the record to determine three things. First, whether procedural due process has been accorded to the applicant. Second, whether the board observed the essential requirements of the law in reaching its decision. And three, whether the findings and judgment of the board are supported by competent, substantial evidence. The record of the case is of course, the transcript of the hearing and all the documents that were placed in the record. I'm sure most of you have seen, because we tell people this, that if you want an accurate record, bring in a court reporter. That's what the court reporter is doing, is preparing a transcript, something for the court to review. I want to talk a little more in detail about the first things a court will review if a quasi-judicial decision is appealed to the circuit court. As I said, under the federal and state constitutions, every person is guaranteed the right to the due process of law when government makes a judicial or quasi-judicial decision affecting that person's right. So the first thing a judge is going to look at is whether the person challenging the decision received procedural due process. It's one of the few things that maybe is appropriately named in the law. Procedural due process addresses the process by which the quasi-judicial decision is reached. And it means essentially that a party has the following rights. First of all, the right to fair notice of what the issues will be. Second of all, the right to a fair opportunity to be heard on those issues. Third, the right to an unbiased decision maker. Fourth, the right to be judged according to defined and established standards and criteria. And fifth, the right to have the decision based upon proven facts. If a judge finds that a party's right to procedural due process has been violated, the court will reverse the quasi-judicial decision. All right, the second thing the court will look at is whether the essential requirements of the law have been followed. What this means is that the court will decide whether the right laws were properly applied or if the right law was applied incorrectly. An example of the wrong law being applied would be if the city had two variance ordinances, one of which applied to the use to which a property could be put, and the other which applied to the type of structures that could be built on the property. And those ordinances had different criteria to be considered. If the applicant applied for a structure variance and the board applied the criteria for a use variance, the court would find that the incorrect law was applied and reverse the decision. I couldn't think of a good quasi-judicial example for the right law being applied incorrectly, so bear with me on this one. An example of the right law being applied incorrectly would be in a case where someone was issued a ticket for running a red light. If the judge interpreted that traffic statute to make it a violation to enter the intersection on a yellow light, the judge would be applying the right statute, but interpreting it incorrectly. If a judge finds that the wrong law was applied in reaching the decision, or that the right law was applied incorrectly, interpreted improperly, the court will reverse the quasi-judicial decision. The final thing a court will look at when reviewing a quasi-judicial decision is whether the decision is supported by competent, substantial evidence. And that's a buzzword. It comes out of the decisions, and every decision uses that phrase. A quasi-judicial decision must be supported by competent, substantial evidence shown in the record, or it's going to be reversed. The phrase competent, substantial evidence embraces three concepts. The first of these is relevance. The evidence supporting the decision must be relevant to the issues to be considered by the quasi-judicial board. In the case of a quasi-judicial decision, the issues are the criteria which the board members must consider. So the evidence must be relevant to those issues. And the definition of relevant evidence in the Florida Evidence Code is evidence that tends to prove or disprove a fact that is at issue in the case. So those criteria are at issue in your quasi-judicial decision. So relevant evidence is that evidence, those facts which tend to prove or disprove the presence or absence of those criteria. Now, the determination of whether particular evidence is relevant is say, ill-defined. But I think it's fair to state that it's a matter of common sense and logic. You know, you pretty much know when someone is throwing a fact at you that's irrelevant to the discussion, or throwing a fact to you that is relevant to the discussion. The second concept embraced by the phrase competent substantial evidence is competency. The evidence supporting the quasi-judicial decision must be competent. To be competent, legislatures and courts have adopted, the evidence must be the type that the courts and the Florida legislature have found to be reliable. So over the centuries, courts and legislatures have adopted rules of evidence. The basic intent of these rules is to ensure as far as possible that the evidence upon which a decision is based is reliable evidence. Now, there is a timeless debate over the rules of evidence and whether it excludes evidence that is reliable or includes evidence that is unreliable. But the good news is that the rules of evidence are not strictly applied in a quasi-judicial proceeding. But there's some fundamental evidentiary concepts that you need to be aware of, and I'm going to discuss those in greater depth in a few minutes. The final concept embraced by the phrase competent substantial evidence is substantiality. The evidence supporting a quasi-judicial decision must be substantial. In determining whether a decision is supported by substantial evidence, the court is determining whether there is legally sufficient evidence to support the decision. Now, what constitutes substantial evidence to support a quasi-judicial decision is a somewhat elusive concept. As a quasi-judicial decision maker, you're entitled to assess the credibility of a witness, determine whether you believe or disbelieve a witness. A court is admonished not to deal with issues of credibility. At the very least, though, the court must be satisfied that there is some relevant evidence in the record which supports the quasi-judicial decision. And sort of the formula that you always read in the cases is, if the court can find some relevant evidence, even if it's a little bit, to support the decision, then the court is going to find that the decision is supported by competent, substantial evidence. Let me give you an example. If the issue is whether a person has run a red light, and there are 100 witnesses, and 99 of them say that the light was yellow, but one of them says the light was red, theoretically, as a quasi-judicial decision maker, you have the right to find the 99 who said the light was yellow were not credible, and base your decision on the one witness who testified that the light was red. Theoretically, an appellate court reviewing that, noting that there were 99 witnesses who said the light was yellow, but one who said that the light was red, would be compelled, assuming they follow their own standards, would be compelled to find that the decision is based upon competent, substantial evidence, because there is some relevant evidence in the record to support the decision. I'm going to talk about the right to an unbiased decision maker. One of the protections afforded by procedural due process is the right to be judged by an impartial and unbiased decision maker. And courts have reversed decisions where there has been proven bias on the part of the decision maker. Bias or an appearance of bias can arise as a result of a conflict of interest or for some other reasons. Bias and conflicts of interest are important for two reasons. First, actual bias, or a genuine conflict of interest, can affect your ability to make an impartial decision and therefore violate the due process rights of one of the parties. Secondly, and this is where city attorneys are concerned, the appearance of bias or the appearance of a conflict of interest may provide a ground for a party to challenge the decision in court. They may not prevail, but there are going to be legal fees for the city if we have to defend those types of cases. Now, there are two Florida statutes, and this is going to be a little tedious, that address voting conflicts of interest. The first of these is Florida Statute 286.012. This statute requires you to vote on an official decision of the board unless you have or appear to have a possible conflict of interest under the Code of Ethics for Public Officers and Employees. The Code of Ethics defines a conflict of interest to be a situation in which a regard for private interest tends to lead to a disregard of a public duty or interest. That's a little vague, I'll admit that. Significantly, the statute allows you to abstain from voting if it appears that you have a possible conflict of interest. Thus, the statute permits you to err on the side of caution and abstain from voting if it reasonably appears that you have a possible conflict of interest. As the city attorney, I encourage you to err on the side of caution and abstain from voting if it reasonably appears that you have a possible conflict of interest. This will avoid giving a party to a quasi-judicial decision a basis to challenge an unfavorable decision on the ground that he or she was deprived of the due process of law. Now, if you abstain from voting because of an actual or a possible conflict of interest, you must file a written memorandum disclosing the nature of your interest in the matter with the person responsible for recording the minutes of the meeting prior to the meeting in which consideration of the matter will take place. However, the statute says that if the disclosure is not made prior to the meeting, you must verbally disclose the nature of your interest in the matter at the meeting, and within 15 days after the meeting, file a written memorandum disclosing the nature of your interest with the person responsible for recording the minutes of the meeting. The Commission of Ethics, fortunately, has created a form for public officials to use in this situation, and the form can be obtained by the city clerk, and if you do abstain, usually the first person you're going to meet after the meeting is the city clerk who's going to run up with you that form. The second statute that addresses conflicts of interest is Section 112.3143. This statute is part of the Code of Ethics. That statute prohibits you from participating in any matter which you know first would inure to your special private gain or loss, or would inure to the special private gain or loss of any principal by whom you are retained, or the parent organization or subsidiary of a corporate principal by which you are retained. And thirdly, you are prohibited from participating in any matter which would inure to the special private gain or loss of a relative or business associate. This is kind of common sense, I would think, but that's what the statute says. Now, a relative is broadly defined. It is a father, mother, son, daughter, husband, wife, brother, sister, father-in-law, mother-in-law, son-in-law, or daughter-in-law. Now, theoretically, you have not violated the statute if you have a relative who's going to experience a special private gain or loss as a result of your vote who's not on that list. Participate is defined to mean any attempt to influence the decision by oral or written communication, whether made by you or at your direction. You have a positive duty to refrain from participating in a matter, even if the parties to the hearing are unaware that you have a conflict of interest under the statute. If it is later discovered that you participated in a matter in violation of the statute, the quasi-judicial decision can be and probably will be challenged in court. Moreover, if you violate the statute, you can face the following penalties: removal or suspension from office, public censure and reprimand, a civil penalty not to exceed $10,000, and restitution of any pecuniary benefits received because of the violation committed. So there's some teeth to this. Now, the Code of Ethics does not define what a special private gain or loss is. In some cases, it may be necessary to research the opinions of the Commission on Ethics as well as judicial cases interpreting the statute to determine in a given situation whether you're going to experience a special private gain or loss according to the Commission on Ethics. And I will tell you, it's a pain to research the opinions on the Commission of Ethics. They're not well organized. So if you believe that the statute may apply to you with respect to a particular vote, I encourage you to seek the advice of the city attorney as far in advance of the hearing as possible in case that research is needed. Like a conflict of interest under the other statute, if the statute applies to you, you've got to go through the same procedure of disclosing your interest in the matter and filing a written memorandum. A conflict of interest is defined by the Code of Ethics, as I've said, or a special private gain or loss are just two of the many situations where an issue of bias can arise. There are many other circumstances that do not amount to a conflict of interest under the statute or a special private gain or loss under the Code of Ethics that may cause you to be biased or give one of the parties a ground to challenge the decision on the basis of bias. Deeply held beliefs, opinions, or positions can affect your ability to be fair and impartial in deciding a matter. Your prior statements or actions can form the basis of a claim of bias. Silly example, or maybe not so silly, an applicant seeking to build a medical clinic to perform abortions may well have a well-founded claim of bias against a board member who has made a prior statement that he or she is opposed to medical clinics performing abortions on moral, religious, or ethical grounds, or who is demonstrated in front of a clinic. A prior close friendship or association with a party can form the basis of a claim of bias. A prior close friendship or association with a particular witness, say an expert witness in a case, can form the basis of a claim of bias, because you may assign, the argument be that you're going to assign greater weight to that witness. Unfortunately, the Florida statutes are not clear on what you should do if you believe you cannot be impartial or are challenged for bias for a reason that's not covered by the two statutes I mentioned. Section 112.3143 tells you not to vote where you will experience special private gain or loss from the decision, but it's possible to have a bias that's not based on special private gain or loss. Section 286.012 tells you not to vote when you have an actual or possible conflict of interest under the Code of Ethics, but defines a conflict of interest as a situation where a regard for private interest tends to lead to a disregard of public duty or interest. It's possible to have a bias that's unrelated to your private interest. Thus, there are situations where bias or a claim of bias may exist that are not addressed by the statute. So what should you do? Well, a literal reading of 286.012 requires you to vote unless you have a conflict of interest. But due process requires that a party receive a decision from an impartial decision maker. I think the answer to this quandary is that the due process right to an impartial decision maker is constitutional law, while the requirement that you vote unless you have a conflict of interest is statutory law, and the Constitution is superior to and trumps statutory law. Therefore, I believe, and there are no decisions in this state, that a court would find that a party's constitutional due process rights are violated where a biased decision maker voted against a party, even though the decision maker was required to vote by Section 286.012. So, my advice is, if you think you may be biased, or if you are challenged for bias for reasons other than those covered by the statutes, first you need to examine your consciousness honestly and decide whether you believe you can render an unbiased, fair, and impartial decision. If there is doubt in your mind whether you can, I suggest that the better course of action would be to abstain from voting and file the memorandum as required by those other statutes. Not only is this consistent with the constitutional principle of due process of law, but it will eliminate a possible basis for a legal decision to the legal challenge to the quasi-judicial decision. All right, I'm going to talk a little about the rules of evidence. As I've said, a quasi-judicial decision must be based upon the evidence presented at the hearing. And that evidence can be testimonial, documentary, or demonstrative. As I said, and it's indeed fortunate, the formal rules of evidence do not apply to a quasi-judicial decision. But remember that when a court views a quasi-judicial decision, it determines whether the decision is based on competent, substantial evidence. Because the judge is a lawyer, he's going to look at the evidence through the goggles of the rules of evidence. Because of this, I think you need to be mindful of some of the most important rules of evidence. In court, there's a distinction between admissible evidence and inadmissible evidence. Admissible evidence is simply evidence that the trier of fact, be it a judge or a jury, or in your case, a quasi-judicial board, may properly hear or see and consider in reaching its decision. In a trial, the judge decides whether evidence is admissible or not. If you watched the Trayvon Martin case, you saw all those hearings that were outside the presence of the jury, and all those times they went to the bench and had those bench conferences. Well, probably half those bench conferences were having the judge decide on admissibility. But there's no judge in a quasi-judicial hearing to make evidentiary rulings on the admissibility of evidence. Thus, the evidence at a quasi-judicial hearing inevitably includes evidence that would be inadmissible if there were a court sitting there to decide on whether you should hear it or not. This places a heavy burden on you to to determine what evidence you have seen or heard during a hearing that you may properly consider in reaching a decision. So the first thing you should look for is, or ask is the evidence relevant? Okay, as I've said, relevant evidence is that which tends to prove or disprove the criteria that must be considered in reaching a decision. So, ask yourself, does this evidence that I find very persuasive, does it really tend to prove or disprove the issues? If it doesn't, then you shouldn't consider it. You shouldn't mention it when you're talking about the case. Another fundamental concept that you should be aware of is lack of personal knowledge. It's a fundamental concept of evidence that a witness may not testify to a matter unless the witness has personal knowledge of the matter. I mean, that seems pretty simple, but a lot of times I've heard people get up and testify at quasi-judicial hearings. I know so and so. Well, how do you know that? Well, so and so told me that, or I read it. So the person doesn't have personal knowledge. It's based upon information obtained elsewhere. All right, hearsay evidence. We've all heard about it. It's probably the most frequent objection heard in courts. That's hearsay. So I'm going to get a little technical. The definition of hearsay is an out-of-court or out-of-hearing statement made by someone other than the person testifying, which is offered to prove the truth of the matter asserted. Example, in order to prove that Sam ran the red light, Johnny testifies that Mary said that Sam ran the red light. Okay, so Sam is the out-of-court person. Mary is the out-of-court person, sorry. Johnny is testifying that Mary has said that, and Johnny is offering that testimony to prove that Sam ran the red light. Well, that's classic hearsay. Johnny didn't see it. There's two evidentiary concerns about hearsay evidence that are, A, you don't know whether Mary really made the statement. And second, and really importantly, there's no way for the parties or the board to question Mary to find out whether the statement is true or how she knows that Sam ran the red light. Hearsay evidence is generally inadmissible, and it's one of the most complicated rules of evidence there is. So generally it should not be considered in reaching a quasi-judicial decision. But I'm going to simplify the hearsay rule for you. There are two exceptions that I want you to remember. The most important exceptions are when the out-of-court statement is made by a party to the hearing. Okay, if a party to the hearing makes the statement out of court and someone comes in and says they heard it, that statement can be admissible because it's made by a party. It may be an admission against interest by that party, something like that. So you can consider an out-of-court statement made by a party to the hearing. The second exception is when the out-of-court statement is made by a witness who's present at the hearing and who can be questioned about whether he or she made that statement out of court. In each case, if you think about it, since the party or the witness who's present, the person to whom the statement is attributed is present to refute the statement or be questioned about the statement. So the following are some common examples of inadmissible hearsay. John Brown testifies at the hearing that he talked to an expert who said that the project would have a negative impact on wetlands. Well, the expert isn't here. That's an out-of-court statement by someone. You can't rely on it. You shouldn't consider it. Because Brown is offering this testimony to prove that the project will adversely affect the environment. Again, the expert statement is hearsay because it was made outside the hearing and it is being offered by Brown to prove that the project will harm wetlands. Second example, a witness testifies that he has talked with many of his neighbors and they oppose the project. We hear that all the time. When I come in, I represent the homeowners association. All my members are opposed to this project. Well, the neighbor statements to that witness are hearsay because they were made outside the hearing and are being offered by the witness to prove that other persons oppose the project. The neighbor's statements to the witness should not be considered by the Quasi-Judicial Board in reaching its decision. A, because it's hearsay, and the other ground is the popularity of the project is not one of the criteria that a Quasi-Judicial Board can consider in reaching its decision. So that would make the evidence irrelevant. Third example, and this is also violated. A witness presents a petition signed by a number of people opposing a project. That petition is hearsay because it represents the statements of the person signing the petition made outside the hearing, and it's being offered by the witness to prove that other people oppose the project. Again, you shouldn't consider that in reaching your decision because it's hearsay, and again, because it's public opinion. Now, I've been mentioning opinion evidence, so I need to talk about it. Evidence in the form of opinions from witnesses who are not expert witnesses is generally inadmissible evidence. There are some exceptions, but the excited utterance exception, things that, frankly, I've never seen apply to quasi-judicial hearings. However, opinion testimony from an expert witness is admissible evidence if it relates to the expert's area of expertise. The court allows experts to come in and offer opinions, to use their knowledge and experience to offer an opinion regarding the criteria of the issues to be considered. Now, an expert witness is someone who is qualified by knowledge, skill, experience, training, or education in a certain area. It's up to you to determine whether whether someone who is testifying an expert has the necessary expertise. Whether that person has the required knowledge, skill, experience, training, or education in an area to render an expert opinion in that area. Be mindful of the fact that an expert witness does not have to have letters behind his name or a bunch of degrees. I prevailed in a case many years ago where the opposing expert was the retired head of the Department of Metallurgy at Harvard. It was a bicycle case. And my witness was an old guy, I can't remember his name, who operated a bicycle shop in Tarpon Springs for 50 years. Okay? And the issue, as I recall, it was whether a bike could have malfunctioned in that way. Okay? Both of those were tendered as experts. The court accepted them as experts, one because of 50 years' experience fixing bicycles, and the other because he knew metallurgy. So you don't have to have letters behind your name. If you've got sufficient experience and knowledge in an area that comes through life, then you can be recognized as an expert. So I'm going to give you some examples of opinion that's admissible. A traffic engineer's opinion that a road complies with state requirements is admissible evidence because the traffic engineer is an expert in that area. A lay witness testifying, that the road does not comply with state requirements is inadmissible because a lay witness, that's not his field of study, traffic engineering. However, importantly, a lay witness can testify to observe facts that may make his testimony relevant. So if the lay witness testifies that he walks on that road daily and he's observed an inordinate amount of traffic, well, that's a fact from which you can rely on or use in making your decision. If he just offers the opinion, then that's not a fact, it's an opinion. A land use planning expert's opinion on whether a site plan complies with the requirements of the Land Development Code and the comprehensive plan is admissible evidence. A lay witness's opinion is not. Now, I don't want to overemphasize the rules of evidence. They're complicated, confusing, and often difficult to apply for judges and lawyers. If you're at a hearing, though, and you have a question where the evidence you are hearing or seeing is admissible evidence, you should raise a point of order and have the chairman ask the city attorney whether the evidence is admissible under the rules of evidence. In all likelihood, I would hope that the city attorney would not make a ruling but it would at least advise you on the principles that you should consider in determining whether that evidence is admissible or not. Because, again, deference is to you as the trier of fact and in some ways the judge. Okay. I'm going to turn to the subject of ex parte contacts or communications. An ex parte contact or communication is any communication with or information acquired by a board member about a quasi-judicial matter outside the hearing on the matter. So the following are examples of ex parte communications or contacts. A conversation with a party or a party's representative regarding a matter you will be hearing. That includes a conversation with city staff. Remember, the city is a party to these hearings, or most of them at least. A conversation with a citizen regarding a matter you will be hearing. That's an ex parte contact or communication. A discussion with the commissioner or the city manager about a matter you will be deciding. Your independent review of documents, maps, plats, plans, sketches, and the like prior to a hearing. Your decision, again, has to be based upon the evidence and arguments presented by the parties at the hearing. And that's part of the due process of law. And what really the principle is here, the parties to the hearing have a right to hear and respond to the evidence and arguments upon which you're going to decide the case. So if you have an ex parte contact or communication or obtain information or review documents outside the hearing, that may influence your opinion. And the parties may not know about that, and they may not have an opportunity to respond to it or point out its relevance or convince you that that's irrelevant. The concern about an ex parte contact or communication is that it may constitute evidence or argument that is prejudicial to the parties. For this reason, Florida courts have held that any ex parte contact or communication is inherently improper and presumed to be prejudicial. A party can challenge the decision in court if the party believes that he or she has been prejudiced by an ex parte contact with or by a board member. In such a suit, the presumption is that the ex parte contact was prejudicial to the plaintiff, the person bringing the suit. And what that means is that the plaintiff doesn't have to prove anything other than there was an ex parte contact or communication, and then I, or whoever's representing the city, has the burden of convincing the court by the greater weight of the evidence that it wasn't prejudicial. I will tell you as a trial attorney, it's not really nice to have the burden of proof. You prefer to be on the other side. So you should disclose any ex parte contact or communication you've had prior to the hearing. You should disclose it at the hearing. This gives the parties to the hearing an opportunity to question you about the contact or communication and determine whether they should challenge you on the grounds that the contact or communication was prejudicial to them. If you disclose an ex parte contact or communication and the parties do not question you about them, or claim prejudice at the hearing or seek to recuse you, there's a strong legal argument that the parties have waived the right to claim prejudice in a later lawsuit. So it's much better to disclose it. 9/10 of the time, parties are just going to move on, and that's going to help us if we ever get challenged. Because ex parte contacts and communications are inherently improper, you should avoid them. And here are some simple rules to follow. If someone wants to talk to you about a matter that you will hear, tell the person that the law prohibits you from talking about it. If someone provides you with documents or evidence before the hearing, and I've seen that happen. I've seen citizens come up and say, look, here's a 1902 plat of the city, and this demonstrates X. In that case, let city staff know immediately so that the applicant can be given an opportunity to review the documents or evidence so that it can be brought out to take away the taint of an ex parte contact. It is permissible for you to go and view a property. It's also permissible to view the original copies of documents such as plans or surveys that will be in your package for the hearing. I know that sometimes you get reduced copies of things. So it's permissible to come into City Hall and ask to see the full plans like me, your eyesight's fading and you just need that. If you review any other documents or evidence outside the hearing, let city staff know so that the applicant can be given an opportunity to review the documents or evidence. Okay, I'm going to talk about your conduct at the hearing. You are an official representative of the city, and your conduct during the hearing reflects on your board and on the city. Some city boards make quasi-judicial decisions that are integral to the economic development of the city. Word gets out in the development community if applicants are treated rudely or with hostility, or if decisions affecting the right of an applicant to develop property or conduct business are made arbitrarily. If the city gets a reputation of being anti-development and anti-businesses, developers and businesses will look elsewhere. That does not mean, by any sense of what I'm saying, that you are here to rubber stamp the decisions of the city. That is not your role. It does not mean you have to ignore evidence or disregard applicable criteria in order to promote development or business in the city. Your job is not to promote development or discourage it. Your job is to make impartial decisions based upon the evidence presented and the criteria to be considered, and let the chips fall where they may. In doing this, you need to conduct yourself with civility and common courtesy. There is no reason to be rude or hostile to any party or witness in a quasi-judicial hearing. In fact, rudeness or hostility, if it's revealed in the record towards a party or a party's witnesses, may be seen by the court as some evidence of bias or prejudice. Even though you are a public official of the city, you do not represent the city or the public or the citizens of the city as a lawyer might represent a client. Your role is to be a neutral and impartial decision maker. So you should not be or appear to be an advocate for one side or the other, or for the city or the public. You know, interestingly, there's no law in the state of Florida that requires that a city's citizens constitute a quasi-judicial board within the city. Oftentimes it's a matter of charter or a matter of ordinance. But I am the Board of Adjustment and the Code Enforcement Board for the city of Reddington Shores. So, you know, I offer that only to show you that the concept of being a quasi-judicial decision maker is one of neutralness and impartiality. The purpose of asking questions of a witness is to obtain information that is relevant to the decision you must make. In my experience as a trial lawyer, a question asked nicely is much more effective in obtaining information than a question asked rudely or in a challenging fashion. I don't know how many of you watched some of this Trayvon Martin case. But those attorneys were not rude to the witnesses. They were not challenging. They didn't shout at the witness. They weren't Perry Mason wasn't challenging, but, they weren't like the TV shows. Just ask questions. Ask them nicely. Ask them to obtain information. You're far more likely to get a response from a witness than with a rude or hostile question. That's going to cause the witness to tighten up. So the following are some good rules to follow when questioning witnesses. Pose your questions in a neutral and civil manner rather than a hostile or confrontational manner. Don't argue with a witness. Don't preface your questions with statements regarding your position or beliefs. Don't express your opinion regarding the credibility of the witness's statements when questioning a witness. You don't have to tell a witness that you find him not credible. You can simply find him not credible in your mind and say, I'm just going to ignore what this witness says. Keep your questions simple and to the point. Simple and to the point questions are easier to understand and much harder for the witness to evade. One of the best trial attorneys I ever met was a young woman attorney with Tyler White. I tried my first federal case with her, and I tend to ask rambling questions in the trial. She asked questions that were like laser darts. I mean, they were like every one hit the witnesses right in the middle of the forehead. And you could tell that the jury was impressed because these were direct, pointed questions that the witness had to answer directly or appear to be, deceptive or evasive. If a witness' response does not answer your question, do not tell the witness that the answer was unresponsive. Rather, and I do this all the time, tell the witness that, I really appreciate that information, but what I want to know is, and repeat your question. If after a couple of attempts, a witness still has not answered the question, then move on. The witness's failure to provide a responsive answer to a simple question is evidence that you may consider in reaching your decision. Okay? If the person isn't going to answer your question, is going to evade your answer, then you can consider that in reaching your decision. Finally, do not ask questions that are irrelevant to the criteria you must consider. This only complicates the issue and provides evidence to an aggrieved party that your decision may be based on something other than the criteria which you're required to consider. All right, I'm going to talk about government and the Sunshine Law. As a public official, you're subject to it. People assume this law is more complicated than it really is. The Sunshine Law requires that all meetings of your board at which official acts are to be taken be open to the public at all times. Stated another way, no official action can be taken by your board unless it is taken at a publicly noticed meeting. Courts have held that official action includes the inquiry and discussion stages of any action by your board. The law also states that no resolution, rule, or formal action by your board is binding unless it is taken or made at a public meeting. And the law requires you to provide reasonable notice of the meetings. The clerk takes care of that. The essence of the Sunshine Law, and this is it, is that two or more members of the same board may not discuss any matter that will come before it or may come before it for official action unless that discussion is held at a properly noticed public meeting. So just remember that the purpose of the Sunshine Law is so that the public can be present and see and hear the discussion, thought processes, and position of public officials when acting in their official capacity. So the simplest way to avoid violating the Sunshine Law is to never discuss your board's business with another board member unless you're at a publicly noticed meeting of the board. Now, the law prohibits any form of evasion to get around the Sunshine Law. You cannot communicate with another board member about matters that may come before the board by email, letter, social media, through another person, or by any other means of communication unless that communication is done at a publicly noticed meeting of the board. The following are two examples of less obvious violations of the Sunshine Law. A board member sends an email to the Planning and Zoning Department and copies other members of the board. The email states that the board member doubts that a pending application will meet one of the required criteria for approval. This violates the Sunshine Law because the board member is conveying his or her position regarding a matter that will come before the board outside of a public meeting of the board. Here's another example. Two Planning and Zoning board members are at a meeting of a civic club. There is a discussion about a proposed new business in town that will have to obtain site plan approval from the Planning and Zoning Board. One of the P&Z board members states at the civic meeting that he opposes the new business. And he states that in the presence of the other board member. This violates the Sunshine Law because the board member's statement communicates his position regarding a matter that will come before the board for official action to another board member outside the publicly noticed meeting of the board. It's just real simple. Just don't discuss your business, your board business, with another member of the board unless, I guess you all meet here, unless you're here and there's a court present. A board member who violates the Sunshine Law can be fined up to $500 and charged with a criminal misdemeanor. If a person files a civil action to enforce the requirements of the Sunshine Law or to invalidate an action in violation of the Sunshine Law and wins the case, the court must assess the plaintiff's attorney's fees against the defendant. And if there's a Sunshine Law violation, the defendant is going to be the board member violating it, not the city. So, in fact, I will tell you that I just learned today from the Florida League of Cities there's a racket in the state of Florida. Two guys who are paralegals from South Florida are going around and making ridiculous public records requests throughout the state of Florida in hopes of getting the cities not to cooperate or to violate the public records law so that they can file suit and assess significant attorney's fees in that process. So these attorney's fees can sometimes be prohibited, at least $4,000 or $5,000 for a very simple Sunshine Law violation. All right, I'm going to talk about the Code of Ethics for public officers and employees. This, too, is a little tedious. Because you are a public official, you're subject to the Code of Ethics for public officers and employees contained in Chapter 112 of the Code of Ordinances of the Florida Statutes. That's a long and complicated statute, but I'm going to talk, and a lot of it is common sense. I mean, ethics is ethics. But I'm going to talk about some of the more significant requirements. First of all is solicitation or acceptance of gifts. You may not solicit or accept anything of value to you, including a gift, loan, reward, promise of future employment, favor, or service, based upon any understanding that your vote, official action, or judgment would be influenced thereby. Now, the phrase value to you means that whatever is solicited or accepted does not have to possess any intrinsic value. I'll give you this Fraser Hubbard pen, which is worth about ½ cent, for your vote. If that's valuable to you and you accept it, you've violated that statute. The only issue is whether it has some subjective value to you. This prohibition applies to solicitation as well as acceptance. So it's violated if you ask for something in return. It's violated if you ask for something in return for your vote, regardless of whether you receive my pen. Okay, there does not have to be, what's that contract term? Quid pro quo. All right, unauthorized compensation. You, your spouse, your minor child, only those three, may not accept any compensation, payment, or thing of value when you know or should know with the exercise of reasonable care that it was given to influence your vote or other official action. I have no explanation for why it's limited to you, your spouse, or your minor child. I would think it would be a little more expansive. The focus of this section is on the intent of the giver. If it can be proven that you knew or should have known that the compensation, payment, or thing of value was given by someone to you with the intent to influence your vote or official action, then you violated the section. I have some questions about the fairness of that, about how you're supposed to know the subjective intent of someone, but that's what the statute says. The third one I think you need to keep in mind is misuse of public position. You may not corruptly use or attempt to use your position or perform your official duties to secure a special privilege, benefit, or exemption for you or anyone else. Now, this one encompasses the whole world. I don't know why. And believe it or not, they're all in the same statute. Corruptly means done with a wrongful intent or the purpose of obtaining or compensating or receiving compensation for any benefit resulting from some act or omission of a public servant which is inconsistent with the proper performance of his or her public duties. I mean, I kind of think that's a no-brainer. don't properly use or attempt to use your position or perform your official duties to secure some special privilege, benefit, or exemption for you or anyone else. And it seems pretty obvious. Now, the city has adopted a code of ethics policy that mirrors the state code of ethics. All right, so I'm going to give you 6 simple rules to live by that should keep you from getting into trouble on any of these. 1, avoid ex parte contacts or communications. Disclose any that may have occurred before the hearing starts. 2, do not discuss the business of your board with other board members other than at a duly noticed public meeting. 3, do not participate in any matter where you have voting conflict or are biased. 4, base your decision on the evidence presented at the hearing and not on public opinion. 5, base your decision solely on the criteria contained in the applicable ordinances. And 6, remember at all times you are a representative of the city and conduct yourself accordingly. That concludes this presentation. I know I've covered a lot of material. You have a handout that addresses the material I covered, and I encourage you to refer to it. If there's one thing I want you to take from this presentation, it's this. I think sometimes quasi-judicial board members don't appreciate, first of all, they feel they're not appreciated by the Board of Commissioners. And I don't think they appreciate their role, their vital role in conducting the city. You know, quasi-judicial boards and the members who serve on them serve an important and necessary governmental function for any city and for this city. And that function is to make an impartial decision on how the city's ordinances apply in specific cases based upon the criteria contained in the ordinances and the evidence presented at the hearing. Just think about that. Think about how important your role is. You are the judge and jury between broad legislative enactment and ordinance and individuals and their specific situations. That's a weighty responsibility, I think, and I think it can be a difficult one. But I want you to take away from this presentation that it is an important one, and you should treat it accordingly. Thank you for your attention.